Right, well, good morning, everybody. And I think it is just after 11 o'clock, so let's start this webinar. Welcome to it. I think we're probably going to have a few more participants coming in the next couple of minutes. But I just wanted to, first of all, welcome everybody. This is, I think, the third or fourth in the series of free webinars that AGBIS is hosting with different partners. Hopefully they are important and helpful and relevant to all participants at this current time. This is our webinar in association with Harris & Clark Rickaby's, and we're very, very grateful to them for partnering with us in this session, and also to the three experts that we're going to hear from and I'm going to introduce in a moment from HCR. The webinar is on the topic of, do we have the power to borrow? Which is really around topics about financial viability in the current situation and going forward for our schools and our governors, and is also about issues around financial distress and how to hopefully avoid it or deal with it if that's the situation we find ourselves in. So it's a very significant and topical issue today. The webinar lasts for about 90 minutes total, and there will be a good time for question and answer at the end. Can I just, on that point, encourage our participants to use the question and answer function on their screen rather than the chat function for posing questions to our panelists. And we'll try to take them, some of them as we go through after each panelist's presentation, and then some of them at the end. And if there are questions that we haven't got time to deal with today, we will pick them up afterwards and provide answers to those when we provide the recording of the session on our website in the next few days. There will also be, at the end of each panelist's session, a short poll question, a very quick snapshot poll of one or two topical things to do with their area that they've been talking about, which I think should be helpful. I would emphasize that these are anonymized. You know, if there's a significant question about your school, don't worry, there's nobody going to be identified. It's simply to get a snapshot of this particular group of participants and where they stand with certain issues that we're going to be covering today. So with that in mind, and reminding you again to use the Q&A function rather than the chat function for your questions, let's start with Kate Hickey. Kate is well known to AGBIS, a friend of AGBIS, and we've done a lot of work with her before. Thank you, Kate. Kate is partner in the education practice of Harris & Clark Rickaby's. She is going to be dealing with charity law issues surrounding the question of borrowing, you know, whether a school has the power to borrow, and if it's doing so in the right sort of way, and if we've checked the right things that we need to check in order to be able to do that. So Kate, I think you've got about 10 minutes to present to us, and then we're going to take some Q&A with you at the end of your session. So without further ado, I'd like to introduce our first panelist, Kate Hickey. Thank you, Richard.
Good morning, everyone. I can't see you, but I hope that you can all hear and see me okay. As Richard has said, I wanted to touch on a couple of things you need to be thinking about if your school is considering the option of borrowing. We don't know, of course, how long the effects of the coronavirus are going to last. It's likely that there has already been an impact on your school's cash position, a projected reduction in the fee income, for example, for the summer term. You may therefore be considering the option of borrowing from a bank. The first thing you should do, if this is something you are considering, is determine whether the charity and/or company which owns the school has the power to borrow. A bank is going to ask for confirmation and evidence of this. The first place to look is your governing document. This might be a trust document if your school is an unincorporated charity, for example, or it might be the Articles of Association if your school is either a charity, which is an incorporated company, or if the school is privately owned. The first thing you are looking for is whether the governing document contains an express provision giving the charity and/or company the power to borrow and to grant security over its assets. This is obviously your best case scenario, and if such a provision is in your constitution, then there is no doubt that you have the power to borrow. If, however, your constitution doesn't have an express power to borrow, you may be able to rely on a general catch-all provision. There may be, for example, a provision which states that the trustees and/or directors have a general ability to further the charity's or company's objects. Your argument in this case would be that in order to further the objects, there is a current need for the school to borrow. The ability to rely on a provision like this will, of course, depend on the exact wording of the provision and your constitution as a whole. And so if you're seeking to rely on a provision such as this, I would suggest getting advice on this at the time. It's worth saying that not all banks, unfortunately, will accept the argument that a catch-all provision like this provides the charity or company with the required power to borrow. But this is a discussion to have with them at the time. If you don't have either an express provision or this catch-all provision in your constitution, or if you're dealing with a bank who indeed won't accept this catch-all, if your school is owned by a charity, depending on the structure of that charity, there may be an implied power to borrow in law which you can rely on. Again, advice should be taken on this at the time, as it can be quite complicated in determining this. One final thing to note in relation to the power you may have to borrow is that there could be, in a worst case scenario, a prohibition on borrowing in your governing document. Whilst this isn't very common, it may exist, and if it does, then alternative options will obviously need to be considered. The obvious one would be to seek to amend your governing document so that borrowing is expressly permitted. In order to do this, you will obviously need to check the provisions of your document to see how you can amend it. Depending on the structure of your charity and/or company, changes to your governing document may be straightforward and simply require, for example, a special resolution to amend it. On the other hand, it may be that you need Charity Commission consent to amend your document or the consent of a third party. So this is something you must check straight away if you determine that you do have a prohibition on borrowing. You can, of course, in the meantime, be holding discussions with a bank, preliminary discussions about the idea of borrowing, but lenders will generally want to see evidence that the school has the power to borrow before taking these discussions too far. Something else I wanted to touch on is whether a bank will require security for the borrowing you are applying for. Where a charity intends to charge the whole or any part of its property as security for borrowing, then it will need to comply with charity law before the borrowing can go ahead. In the same way as we need to check the Constitution in relation to the power to borrow, you also need to check the Constitution to ensure that you have the ability to grant security over the property of the charity, or whether there is indeed a prohibition again in relation to this. In addition to this, there is also charity law which states that when granting a charge over charity land, you need to comply with section 124 of the Charities Act before the borrowing can go ahead. This is there to protect the charity's property. In short, it provides that any mortgage of land held by or in trust for a charity requires either an order of the court or the Charity Commission, unless the trustees have, before executing any security documents, obtained and considered proper advice given to them in writing. So what constitutes proper advice? This includes advice that the loan or grant is necessary, thereby enabling the trustees to carry out the action for which they are seeking the loan or grant. In other words, it's necessary for them to carry that out. The terms of the proposed loan or grant are reasonable, having regard to the charity's status as the prospective recipient of the loan or grant, and the charity can repay the proposed loan or grant on the proposed terms. Helpfully, there is Charity Commission guidance on this, which states that where appropriate, favourable terms should be obtained, usually where a charity represents a low risk to a bank. It goes on to say that they would expect this to be considered as part of the proper advice given, and that a charity should be able to make repayments without prejudicing its other financial activities or commitments. So the final question on this is, who can provide this proper advice to you? Charity Commission guidance states that this should be someone whom the trustees reasonably believe to be qualified by his or her ability in and practical experience of financial matters, who has no financial interest in relation to the loan. It should be noted that a suitably qualified employee of the charity is specifically permitted to give this advice. So, for example, arguably, the bursar could provide this advice. In deciding whether a particular person has the ability and experience to advise you as trustees, you must consider the nature and complexity of the transaction for which advice is being sought. The Charity Commission cannot consider the credentials of individual advisors on behalf of the trustees. They leave that to you. The matter falls within your discretion as trustees. So the important thing here is that if your school is being asked to provide security in relation to any borrowing, and you wish to avoid the need to go to the Charity Commission or the court to get consent, which of course you're going to want to avoid, then you need to ensure that there is no prohibition in your constitution in relation to granting security. That's the first thing. And then that you seek proper advice as defined in relation to the granting of that security, and that you're able to demonstrate that you have considered who should be giving that advice. One last thing that I just want to mention is the fact that if your school is an unincorporated charity, it's really important to consider the implications of that when you are thinking about borrowing. As you will probably be aware, an unincorporated charity does not have a legal structure of its own or separate legal entity. Contracts and other obligations, therefore, cannot be entered into by it, and property cannot be held by an unincorporated charity itself. This means that the loan, and usually any charge over the charity's property, would be entered into by the trustees personally. This is obviously something that the trustees would need to consider and understand before doing so. Trustees who enter into a loan or grant security on behalf of an unincorporated charity are personally, jointly, and severally liable to repay the loan and for all the liabilities associated with it. This obviously sounds incredibly scary, and you're thinking, Kate, why on earth would we do that? The good news is that trustees are entitled to be indemnified out of the assets of the charity for liabilities they incur on its behalf in the normal course of its lawful, that's important, lawful activities. So therefore the issue here is that if the assets are insufficient to meet the liabilities, then the trustee or the members may be personally liable for the shortfall. So unless your liability is successfully limited in either the charity's governing document or the contractual terms entered into on the charity's behalf, in this case with the bank, your potential personal liability as a trustee for any shortfall will be unlimited. So what does this mean? It means if you are an unincorporated charity, then what you need to think about is, what assets do we have? if you, for example, are part of a large foundation and there are a lot of assets within your foundation, you may decide this isn't as high a risk. But my advice would be, irrespective of any of the assets of your charity, I would advise you to ensure that the terms of any bank loan that the charity enters into states that the trustee's liability is limited to the assets of the charity at any time. So that is a particular express provision that you would request the bank to include in the documents. And a bank, I would say, is used to seeing this. So it shouldn't be a problem, but it's obviously incredibly important for you as a trustee. I hope that's been helpful. Richard, I'll hand over to you.
Thank you very much, Kate. Very helpful indeed to set the scene. I know we've got a question or two, which we'll come to in a minute, but I just wonder if we want to run, there's a couple of quick poll questions just to sort of get things going after that, if we may. If we can have our first poll question up on the screen. So two questions actually, let's take them both together. Are you considering borrowing? In other words, your school that you're representing here, considering borrowing? And have you looked at your constitution to see if you have the power to borrow? Yes or no? So if we could just ask all participants to answer those. The host and the panelists cannot vote on this, so this is only the participants. It'd just be interesting to see. So if we could ask you to click yes, no, or not sure for question 1 now. And yes or no for question 2 now. And then we'll just give it a few seconds before we can compute the how the answers have come out, just for interest. Okay. Can we have the answers on the screen? Is that possible yet? Okay, we might need to come back to those answers. They're probably still being run through the, oh no, here we go. Thank you very much. So we've got a 50% who are considering borrowing and a split, not sure and no, on the other side of it. And in terms of looking at the Constitution, 65% have answered yes and 35% no. So clearly I would imagine from what Kate said that it's important that if you're in that 35% after this, maybe one of your actions is to go back and look at your Constitution and check whether you have got the power to borrow and follow Kate's guidance on that. So that's very helpful. Thank you ever so much for that, Paul, and we'll do 1 or 2 more as we go on. So, Kate, can we come back to you? There are a couple of questions that have come in. I think certainly one from Andy and one from Gillian. I don't know whether you've got them on your screen.
Yes, I can see the one from Andy. I can't see, oh, and now I can see the one from Gillian as well.
Okay, do you want to take those now then? Just
okay.
read the question first and then give us your thoughts.
Okay, so from Andy, with reference to Kate's comments about legal entity, what if the school operates under a royal charter or the Public Schools Act as a body corporate? So I'm just going to sort of guess what this question is getting. I think what I'm being asked is what structure is that in relation to a charity? So if your charity is operating under a royal charter or the Public Schools Act, then this is an unincorporated charity for the purpose of what I was just explaining in relation to your constitution. So this charities that operate under those acts are unincorporated charities. So they will have a constitution, and it is that constitution which you need to check to see if there is a power to borrow. And the implications of them being unincorporated are, as I just mentioned at the end, the consideration of the fact that there is unlimited liability for the trustees, but also, importantly, it's very, very difficult to amend a constitution where your charity operates under a royal charter or a Public Schools Act. It's possible, but it takes a lot of time. And so, yeah, I hope that answers the question. But so the first thing is have a look at it. Is the power there? And then if not, I would say it's a case of taking advice to see if there's any implied power, which there may well be, which would obviously be the best case scenario if there isn't an express provision. So I hope that answers that one. And I'm just having a look at Gillian, I believe, has asked a question. Are there any procedures which may change depending on the planned use of the loan? So I'm just trying to decide what that question is getting at. Are there any procedures which may depend on? I think what you're saying is, in relation to your power to borrow, is there anything different from what I've said, depending on what the planned use of the loan is? And so I guess there's two ways to answer that. The first is no, in that you still need to borrow money at all from a bank, for example. You need to have the power to do that, either in your constitution or an implied power in law. But you must always operate within your objects clause. In other words, you must always use any funds that the charity has to further your purpose. So therefore, even if you've got the power to borrow, what you couldn't do is borrow money and use it to do anything. I may be stating the obvious here, but so the purpose of the loan is important for that. In relation to that, the purpose for the loan must be to further your objects. But as far as the power to borrow, then it's that same power.
Kate, thank you very much. I think that point about relating back to your objects is a crucial one for all charity trustees to remember all the time. That's what we're there to deliver, and everything we do has to relate back to that in terms of the legal position as trustees. So that's what we're there to deliver, top and bottom of it. So that relates to this situation as much as others. That's really helpful. Can I ask you one quick follow-up before we move on from this section, Kate, on being unincorporated? So I'm going to ask what we used to call in Scotland the daft laddie question, naive question, if you like. Given what you've said, why on earth would any school remain, or any body remain unincorporated?
So that's a very good question. That's a very good question. And my advice would have to be that you don't really want to stay unincorporated. And my advice would be, when all of this has blown over, I would strongly recommend your board of governors, trustees, to look into becoming an incorporated charity. What we find is there are quite a lot of charities, especially ones that were established a long time ago, who were obviously set up unincorporated, and I know it sounds crazy, ridiculous, but just have not got round to becoming incorporated. It's quite time, it's compared to other things thought of as a bit time consuming. You're probably looking at, on average, perhaps about 6 months, let's just say, because to become incorporated, what you need to do is set up a new charity and transfer the assets from your current charity to that charity. So it's probably about a 6-month process. So the very simple answer is, it's often either trustees don't appreciate the implications of not being incorporated, or once they do, it's something that's on their to-do list, but they haven't got round to. So my advice would absolutely, and I think something like this highlights the importance of being incorporated, and I would keep it on the to-do list and get it as quickly as possible.
Well, that's very helpful. I mean, in the current crisis, time may not allow, I suppose, but on the other hand, it's really important one not to forget. In fact, absolutely. I wasn't quite as daft as I was making out, because a school that I was head of, that was the situation, a big, well-known school. It was unincorporated, and
yes,
we went through the process. It took a long time. It's very hard work. You do need to focus on it, but Without that, we couldn't, well, it would have been much more difficult to do the things we wanted to do. Anyway, I'm going to there's one final question for this, which I think is quite important actually, before we move on, if I may, which is, does your advice apply in Scotland? And I think we need to bear in mind, that the charity regime, certainly in Scotland under Oscar, is not quite the same as the situation south of the border and in Wales and so on. So could you just take that one on very briefly, and I would ask you to just be as brief as you can on that.
Yeah, no, that's fine. I mean, to be honest, Richard, it may be one that it's better to come back to and provide a proper response after this. But I mean, what you've just said is absolutely right. It's not, the Charity Commission regime is the same in Scotland. And so it is a different regime. So I'm obviously speaking in relation to, not in relation to the Scottish one, but it is certainly what I think the best thing would be if I provide an answer and show some comparisons.
Yeah, I think that would be really helpful. So after, when we record the session, we'll also provide answers to that and other questions that we can't finally deal with in this session. But Oscar regime in Scotland is slightly different from Charity Commission. So thank you ever so much, Kate, and I'm sure everybody appreciates that excellent session to start with. Do keep the questions coming as we go through the next sessions, please. And I would now like to move on to the second presenter from the HCR team, who is Russell Jarvis. Now Russell is a banking lawyer with, I think, over 20 years experience in working in different sectors, including, of course, education, very importantly. And he is the head of the London banking and finance team for Harris & Clark Rickaby. Russell is going to be talking particularly about financial distress and trustee duties in that situation. So thank you very much, Russell. We look forward to hearing what you've got to say to us.
Thanks, Richard, and good morning, everybody. Obviously, at the moment, the key sort of approach that people are adopting is about surviving and getting through this crisis. And in terms of practical way that's being approached, it's all around minimizing monies out and maximizing the liquidity in the organization. And for those steps to be undertaken as quickly as possible, obviously we're some way in, so some of those will already been taken, but it's about the speed of getting those changes through. And also it's a little bit about thinking about preparation for the future. What's going to happen in the next 3 to 6 months, and so getting prepared for the future as well is obviously important. A couple of caveats to some of the things I'm going to say this morning. Firstly, we are some way into the crisis, and so I can assume that some or all of the approaches that I'm going to outline are already being adopted or being followed. The second approach, obviously, the second caveat is all around the fact that obviously there are a number of different size and scale of institutions involved on the call, so not all approaches are appropriate. I mean, for example, some organisations will have significant reserves, others will have none at all, and that again drives your approach. But the key to getting through and surviving at the moment is very much has to be a multi-layered approach. So it's about looking at lots of different sorts of approaches and utilising whichever ones work and are the best fit for your organisation. Clearly, the key partner in this crisis is going to be your bank. The government approach is very much at a macro level. It makes the assumption, I think, that your bank has got liquidity to support you in this crisis. The government will stand behind the bank's liquidity, and I'll talk a little bit about that in the future. But the key approach, the key relationship really is with your bank and your bank manager. I'm sure many of you have already been talking to him or her, but I can't emphasize enough that you will get priority attention if you approach your bank manager, because you are a customer. And they are looking for banks are looking primarily to support their existing customers at the moment, rather than people that are out there in the market generally with difficulties. First step, really, I suppose, very simple. If you haven't got an overdraft, get one. If you've got one, think about getting a bigger overdraft. The reason why I say that is because going back to what I said earlier about speed of decision making, you will find that your bank manager is currently in a position to make a very rapid decision about an overdraft. And so you will get a quick decision. There'll be no need for any formal credit process. And so that will give you some instant liquidity. How much you should ask for, obviously you've got to have regard to your existing liabilities and things that you need to meet in the next, you have been meeting and need to meet in the next couple of months. But you do need to think a little bit about coming out. And so if there are anticipated items of expenditure which you want to cover off with an overdraft, then factor those into your request. It's easy to ask for only one overdraft or one overdraft extension. It gets more tricky if you have to go back for a second bite of the cherry. So think about the quantum you want, think about now, getting through, and the future. And that's very, very important. Step two, a number of you, I imagine, will have existing borrowings with a lender in place. At the moment, most banks are giving capital repayment holidays. And I've seen a big range from 3 months to, I've heard Barclays are giving 12 months. So there's a huge range in the capital holiday period that you can ask for. Why would you do that? Well, again, it's all about a quick decision. You will get a decision from your bank manager very, very quickly. And so you can pretty much straight away put that on the back burner. The interest will continue to roll up on that loan. And the effect is basically the term of the loan gets extended for the amount by which you ask for the holiday. So you don't not have to pay it. And as I say, the interest keeps rolling up, but you get it added on. So it gives you a timing. It's a timing issue, really. You will, I've no doubt whatsoever that because of the current market situation, you will be in breach of the various covenants in your existing banking documentation. But banks can exercise what they call in an old-fashioned way forbearance, which is, in other words, they won't enforce your breaches of covenants and your loan documents. They'll let it go by. And if you can add in, as I say, the capital and interest, or certainly the capital holidays, then that will give you quick liquidity quickly. The third kind of step really is really around the various government support schemes. Now, I've just picked up on 3 of these because I think these are the 3 probably most relevant to people on the call. The first is the very well-known government furlough scheme, which is, as you know, probably up to £2,500 payable to an employee till the end of June. It's quick to access, and there's been a massive take-up of it. I heard a figure of over 6 million workers are on this scheme. It's suitable, I think, in a schools context, particularly for non-teaching staff. There'll obviously be some essential staff that you need to keep on, but for those that are non-essential, then that scheme is an excellent scheme for them. The mood music at the moment is that we apparently as a country are getting rather used to being on furlough, so it's undoubtedly going to be coming to an end with effect probably from the beginning of July, and I suspect there'll be a step down process, so we're talking about 80%, 60%, 20%, so that institutions hopefully have the time to get themselves back up to speed, and income is coming in so they can meet normal wage bills. But as I say, that scheme, hugely popular, very easy to access. You get the cash very, very quickly, as I'm sure a number of you have found a good scheme. The next scheme, the next 2 schemes really are around government guarantee schemes. Now, just to be clear, this is not money that the government lends to you. This is money that the government, to a varying degree, guarantees the repayment of to the bank. So you make a loan application in the usual way. If for whatever reason you default, then the lending institution can apply to the government to have that money repaid. So it's a guarantee to the bank. It's not a relationship with you as an organisation. The 2 kind of key schemes. The first one is the bounce back loan scheme. I kind of like that name. I think that's a really positive message name. The BBLS, that is designed for smaller businesses. You'll probably have noticed it in the press. It was released earlier in the week. There has been an absolutely massive application for this particular scheme. It's because it's a quick decision. It's a 2-page app that you make to your bank. It's a pro forma. You can get up to 50k on that scheme. It's a flat rate of interest, fixed rate of 2.5% over 12 months. And that scheme, as far as the bank is concerned, is 100% guaranteed by the government. So it's a very quick scheme, a very quick way of getting money into an account, but it is only for smaller businesses. The next scheme up, which is for what we will call medium-sized businesses, is we call it CBILS, which stands for CBILS, which stands for Corona Business Interruption Loan Scheme. That is an 80% guarantee given by the government to the funding institution. It's designed for medium-sized sort of businesses. So, I mean, turnover of up to £45 million, which will certainly cover most schools that I'm aware of, but is certainly the scheme that allows you to make the larger applications. It is an exclusive application. You can't apply for both the bounce back scheme and the CBILS scheme, in case you were thinking you'd go for 2 lots of money. There's only one lot of money. The minimum loan application size is 100k. You can apply to up to £5 million. You have to have a turnover of more than 1.5 million, and so that sort of thing. The loan can take any form. It can be in the form of an overdraft, a term loan, asset finance. If the loan required is more than 250k, then you may be asked to give a personal guarantee as a trustee, and that will be that would be a significant issue for you. But you can probably back that off in terms of getting your liability underpinned by the rest of the trustees. The HMG pays the interest and capital for 12 months. The kind of take up on that is, as far as I can see, it was slow at first, but now banks are really powering those applications through. That is a very popular method. The key really to both the government schemes really is about the nature of the viability of your business or your school institution beforehand. If you were an institution that was struggling in the years, say I think typically 3 years, in the 3 years prior to this crisis, you will have difficulty in accessing those schemes, because the way the scheme works is that the government is relying on the banks making prudent lending decisions. In other words, they are not just going to lend money to institutions that were going out of business or were really struggling. It is about businesses that are only affected by COVID-19 and pre-COVID-19 were viable. So that is a very important caveat. The kind of fourth kind of collection of measures, really, I suppose, and miscellany really, is around looking at some of your other interfaces and seeing whether there are funds that you can access from those institutions. The first thing, really, I suppose, is to look at all your third-party commercial contracts. So you will have a number of contracts with external suppliers for the supply of goods and services. Take that contract out of the drawer, look and see whether in that contract there is a provision for what we call force majeure. Force majeure effectively is a concept that enables both parties, either party, to walk away from a contract if it's incapable of being performed because of business circumstances. Now, it's highly likely that you can argue that the COVID-19 makes the contract unenforceable for any number of reasons, and therefore it's unenforceable. So if you've got contracts that you don't, I'm reticent about telling you to just go around willy-nilly terminating contracts, but if you've got contractual relationships that are not essential to the survival of your business at the moment, pick them up and terminate them if you can. If that's not capable, then in terms of those suppliers of goods and services, it's worth having practical conversations about extending their terms, so that you don't have to pay for a period of time. So that it's worth, if you've got those great contractual relationships that you don't want to terminate for force majeure provisions, you want to continue them, engage in a kind of positive dialogue around seeing whether you can't get the timing and the delivery extended during this period of crisis. The second area is obviously business rate holidays. Most local authorities are providing those, and it is worth taking those up if you can. The third step, I suppose, is what we would call local authority grants. Local authorities have been extremely efficient in giving grants of up to £15,000 to businesses in their local area. You can get that money up to £15,000 within a couple of days, I've seen. It's a very simple pro forma sheet to fill in, and that money is coming through very, very rapidly. The kind of final thing really, I suppose, is around your insurance. Business interruption, there's a big dialogue going on at the moment as to whether or not this crisis constitutes a business interruption event in terms of your insurance policy. Now, not many insurance policies will have that as in specific wording, but it's certainly worth having a dialogue with your broker to see whether you can't get that insurance kicking in and helping out in this difficult time. So those are the sorts of steps I think I'm seeing across a number of different sectors. And it's, as I say, it's all about surviving, getting through, and thinking a little bit about the medium-term future in terms of coming out of this situation, which I think we are now starting to do. So that's yeah.
Thank you, Russell. That was a hugely helpful and very practical set of thoughts, and I'm sure that people will have some questions on some of those things. I've got a couple of them myself, but just before we get to those, perhaps we could just have the poll question that might come up after your presentation. If we could have that poll question on the screen, that would be really helpful. Thank you. There it is. So, has your school accessed any of the government guarantee and support schemes since the crisis started? I'm going to make a personal guess at the percentages that are going to come out on this one, but I won't tell you what it is right now. So thinking of your school then, has it accessed any of the government guarantee and support schemes that have been mentioned since the crisis started? Yes, no, or not sure. If you could vote on that now, that would be brilliant. And then as with last time, it'll just take us a few seconds to come up with the answer to that one. We'll wait for that for a second or two. Just while we're waiting, Russell, maybe I'll break off if we get the exit poll result. Oh no, here we are. Okay, no, I was wrong. I thought the answer was going to be 100% yes, and the answer is 85% yes and 12% no, with 2% not sure. So that is actually, although it's high, affirmative answer, it's slightly lower than I had expected. But there we are. That's obviously shows the range there. Does that surprise you, Russell, or is it just me that's a bit surprised?
No, I think we've got what I imagine, Rich, is we've got a huge variety of institutions on the call, and some have just got deeper pockets, deeper reserves, and they're dipping into those reserves, and I think that's keeping them going, and I think they're adopting all the other measures of ameliorating their cash flow, and I think, you know, I'm seeing generally, certainly from larger institutions, quite a robust and pragmatic approach. So no, it doesn't surprise me entirely, to be honest.
Russell?
Yes. Okay.
Hi, a couple of questions have come in from participants. Are you able to have a look at those?
Yeah, I'm just flicking them up now. Yeah. I see they're mainly around, well, I've got a few around insurance claims.
Right.
Yeah.
I'm sorry about that. I had a technical problem there, and somehow or another I came out of the meeting. Can you hear me now, Russell?
Yeah, I can hear you. Richard. Yeah, I'm just looking at some of the questions that have come through.
Yeah.
they're around the whole insurance approach, which I have to say, I'm not completely up to speed with what the current position is. I do know that there are discussions going on at a very high level about the use of business interruption insurance. Insurers are naturally resisting that. I think it's one of those that you just, you start that dialogue with your insurance broker, and you keep pressing them. You keep pressing them, you keep pressing them. And I'm hopeful that there will be something come out, but I don't know exactly what, and I don't know how that guidance is going to come out. But I think it's something that, as I say, there is some pressure for the insurance industry to chip in this space.
If I could just jump in for a second. Hi, it's Kate. I believe we are running a webinar on the 21st, which is actually going to look at business interruption insurance. So that would be one worth joining. So that's the 21st of May, and that will address, look at business interruption insurance and the issues to consider there.
Thank you. What one to put in the diaries to follow that up, I think. Russell, can I just come back with a question? And again, I apologise for dropping off the meeting for a minute, technical reasons, but hopefully everyone can hear me again now. You talked about the different government schemes and the smaller business loan scheme. Would that apply to our schools, do you think, or is that really for business? Would there be any of our schools that would really qualify for that scheme? Or would they all really be in the CBILS scheme?
I think it really depends on. I mean, the loan figure is up to £50,000. So I mean, I think if there's not a turnover caveat there. There's not a as far as I know, there's not a limitation as to who can and cannot apply. The key website really to check this information is the British Business Bank's website, and they set out in some detail. You log onto that site, they'll set out in some detail the availability criteria. But no, I think I mean, in some ways, bizarrely, actually, the bounce back scheme should have been the first scheme that came out, because actually it's the smaller businesses that have been hit the hardest, quickest. So ironic that it's come out at the end, but the take up has been phenomenal. And I think it's because of the simplicity of application. It's just literally two sides of pro forma, tick, 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 tick. Yeah. And money comes through pretty quickly, I'm seeing.
Yeah, I know. We are all. The trouble is, we're all going to get used to it, aren't we? And your point about sort of coming off taking the punch bowl away gradually is going to have to apply in all these other ways too. But you know, this is going to be a long run matter. But can I just ask you one other question? It's quite possible, by the way, that I lost some of the Q&A function when I dipped out the meeting and came back. So if I've missed something, somebody else please come in with another question that's been posed. But Russell, just one more from me before I finish on this bit, which is you talked about going to your third-party commercial contracts and so on,
yeah,
and looking at the force majeure element. But if schools, and I think a lot of schools have been very loath to go down the force majeure route with, for example, their parent contracts, because that's their contract, obviously, with their clients. You know, what's the law around going to force majeure with your third-party commercial contracts if you're not using it your own contracts, as it were? Is there a problem there? Well,
I think each contract is a standalone contract, so I don't think there's a. I think it's negotiated. The assumption is that they're all negotiated on an arm's length basis, so you can treat them individually.
But the advice to go to those contracts, get them out the drawer, as you said, look them up on your system or whatever, and negotiate where you can, is a bit like going to the banks, because it's all about, this is the time to do it. If you don't do it now, the moment will have passed. Same with your contracts.
Yeah, I mean, a lot of them will be long-term suppliers. You won't, you know, they'll be in difficulty themselves. But what I've been finding across business and industry is generally that if you've got those long-term relationships, there is leeway being given. Yeah. If leeway is not being given, then you might want to revisit.
Okay. Thank you very much. Okay, any other questions that I've missed from it? Please, any of the other panelists, if I've missed something, because I dipped out, please do come in, or if there's anything outstanding before we move on from Russell's section, which has been brilliant, by the way.
There is, it's just Kate here, there is one question, but Russell, it may be one that you want to revert on after this. The question is, if there is still 70% of income coming into a school, could that be seen to be business interruption? If not, what percent would be? But as I say, it could be that that's one to go back on after this.
I think I'd rather go back on after this because I probably want to speak to one of my partners, Adam Finch, about the wording around insurance. But I'm happy to deal with it on a separate basis. Yeah.
Or as I say, it may be covered in our webinar on the 21st. No, that's perfect.
Good plug, Kate. Good plug.
Don't worry, we'll get another plug before the end. Thank you very much indeed. That was great, Russell. And just to reiterate that, any questions we haven't managed to pick up in the whole session today will be picked up and posted with the session on recording afterwards. So thank you very much. Can I, with that, thanks to Russell again, can I move on now to Paul Grundy, who is our third and final panelist from Harrison Clark Rickaby. Paul is a senior associate solicitor with HCR in the Restructuring and Insolvency team, and he's the sector lead for education on restructuring and insolvency issues. These are words that we don't really like to think about all the time, but some of us have to, and it's better to think about it than bury one's head in the sand. So it's really important, I think, this session from Paul, who will be talking about governors and trustees' duties to things to consider when making key decisions, which include some of the things we've been talking about there. So Paul, thank you very much indeed, and we look forward to hearing what you've got to say.
Yes, thank you, Richard. I'll just start my time. I'm conscious I've got quite a lot to pack into a fairly brief slot, and it follows on really from what Kate and Russell have already told you about this morning. So Kate has addressed the issues around your powers to borrow and can you borrow. Russell has looked at what you might actually look to borrow and different sources of funding. And I'm going to be looking at, as Richard said, duties of the trustees, and the question really about should you borrow, because the implication of borrowing is obviously increasing the school's liabilities. We've already said that around 50% of you are considering borrowing in the poll, and a further 28% of you aren't sure yet, the poll that we've already taken following Kate's helpful session. So moving on from that and considering the duties that the trustees need to consider, the governors and trustees need to consider when looking at borrowing and taking key decisions. Being a governor or a trustee is a broad church of responsibility, which includes overseeing the financial performance of the school, managing budgets and deciding how the money is spent. It includes holding the head teacher to account for performance of the pupils in the school, and that includes performance reviewing the head teacher and the senior leaders, including making decisions about pay. And it also includes ensuring clarity of vision, ethos and strategic direction of the school, which may include engaging with pupils, staff and parents in the school community, and also looking at data and evidence to ask questions and have challenging conversations about the school, which need to be had at times, particularly in current circumstances. Therefore, when making those key decisions, school governors must consider their legal obligations as well as their duties to the beneficiaries, which include the pupils and parents, key stakeholders, including any lenders and any other unsecured creditors. According to the Commons Library briefing on the 17th of October 2019, the Department of Education figures suggest that of the 2,300 independent schools in England, over half of them are registered as charities, and the Independent Schools Council estimates that of their membership, around 74% are charities based on their 2019 school census. Therefore, the duties that governors and trustees have to consider in many cases are a hybrid of duties from charity law, company law and trustee law, depending on how the school's constituted. Independent school trustees and governors must act with integrity and objectivity and honesty and in the best interests of the school. They must act within their powers and obligations, be open about their decisions and actions, and also be prepared to explain the decisions and actions to those who have a legitimate interest in them. Under charity law, the trustees have ultimate responsibility for directing the affairs of the school and ensuring that it is solvent, well run and delivering the charitable outcomes for which it's been set up. And again, that goes back to the charitable objects and looking at the company's constitution, which Kate mentioned in response to her Q&A session. Charity trustees occupy a fiduciary position, and obviously that therefore demands a particularly high standard of trust and confidence in their actions and them. Trustees have several legal duties, often referred to as the duties of compliance, care and prudence. Just briefly running through those in that order, the duty of compliance is to ensure that the school complies with charity law, in particular ensuring that the charity prepares its reports, its annual returns and accounts is required to be filed by law. It is to ensure that the school doesn't breach any of the rules set out in its governing documentation or its funding agreement, and that it remains true to the charitable purpose and objects set out. It's to make sure that the school complies with requirements of other legislation and other regulators which govern the activities of the school, and to act with integrity and avoiding putting themselves in a position where their duties as a charity conflicts with their personal interests or loyalty to any other personal body. The duty of care says that trustees must use reasonable care and skill in their work as trustees, using their personal skills and knowledge and experience as needed to ensure that the school is well run and efficient, and to consider getting external professional advice on all matters where there may be a material risk to the school or where the trustees may be in breach of their duties. Finally, the duty of prudence. Trustees must ensure that the school is and will remain solvent, must use funds and assets reasonably and responsibly and only in the furtherance of the objectives of the charitable objects of the school. Must avoid undertaking activities that might place assets or the reputation of the school at undue risk, and must take special care when investing or borrowing funds for the school's use. In instances where the school is a charitable company limited by guarantee, the trustees also have statutory duties as directors under sections 170 to 177 of the Companies Act 2006, which is modified for directors of charitable companies. But in a number of instances, these duties overlap with the core charitable duties. Briefly running through those are the duties to act within the powers of the school's governing documentation and constitution. The duty to promote the success of the school for the benefit of its pupils and staff, to exercise independent judgment, to exercise reasonable care, skill and diligence, as is reasonable in the circumstances having regard to any knowledge or experience that they have, or if they're acting in a professional capacity as a trustee, then any special knowledge or experience that it would be reasonably expected that professional to have acting in their capacity. A duty to avoid conflicts of interest, a duty not to accept benefits from third parties, and a duty to declare interest in transactions or arrangements that they may have with the school. Also, there are various considerations. As I said, it's a bit of a hybrid depending on how the school is constituted, but there will be other considerations under the Charities Act 2006, 2011, the Education Act 2002, and also the school governance regulations and codes. So far as the Companies Act applies to a charitable trust, so do to the consequences of breaching the duties which I've already mentioned. So the ramifications of breaching those duties could include disqualification from acting as a charity trustee under the Charities Act 2011 or the Company Directors Disqualification Act 1986. Under the Company Directors Disqualification Act, the court may disqualify a person from being a director of a company or in any way concerned in the promotion, formation or management of a company. And in lieu of proceedings for disqualification, disqualification undertakings are often accepted for the person not to act as a director or a charity trustee. There are also penalties of a fine and or imprisonment for offences of acting as a trustee of a charity whilst disqualified. The period of disqualification under the Company Directors Disqualification Act can be quite lengthy, and it's anywhere between 2 and 15 years depending on the level of culpability and wrongdoing. The possible grounds for disqualification are extensive, including persistent breach of the statutory requirements, including company law, so failure to make requisite filings, fraudulent trading, or general unfitness to be concerned in the management of a company where the company has become insolvent. Another implication of failing to meet those duties is personal liability for the trustees. A charity trustee of an incorporated charity is not ordinarily personally responsible for the liabilities incurred, subject to obviously anything that Kate has said. Kate mentioned unincorporated charities and the liability of the trustees there, but in terms of incorporated charities, they are not normally responsible. And they would enjoy a right of indemnity from the company or the charity or the school for liabilities incurred when carrying out their duties responsibly and in good faith. Therefore, if an incorporated charity's assets are insufficient to meet its liabilities, that entity will be insolvent. The Charitable Incorporated Organisations Insolvency and Dissolution Regulations 2012 apply the Insolvency Act 1986 to charitable incorporated organisations with some modifications. However, similar to the position of directors of a charitable company, charity trustees of a school may be criminally or personally liable under criminal and civil law in certain limited circumstances. And those circumstances may include, but not be limited to, if they receive unauthorised payments or benefits from their role as governors or trustees of the school, if they act or in breach of trust or in breach of duties and a loss is caused as a result, if they've acted deliberately or recklessly and or have been misfeasant in how they've carried out their duties in office, if they've traded while the company was insolvent and failed to take all reasonable steps to prevent the further liabilities that have accruing, and that's known as wrongful trading. If they fraudulently traded and acted and caused the charity to incur a loss, which is often known as fraudulent trading, and also by acting as a charity trustee whilst you are already disqualified. The Charities Commission has power, as does the court, to relieve a charity trustee from personal liability for breach of trust or breach of duty if they've acted honestly and reasonably and ought fairly to be excused. And those discretionary powers are contained in section 1157 of the Companies Act 2006 and section 191 of the Charities Act 2011. Just moving on briefly to wrongful trading, I mentioned that above. The principal duty of the trustees is to promote, and the school is to promote the learning and success of the school for the benefit of its pupils. And that has effect, but it's always subject to any other rule or statutory requirement that the trustees must consider or act and prioritise the interests of another group of people, in this case, the creditors. If a charity trustee allows the school to continue to trade when it's in the twilight period and potentially insolvent, the court may require them to contribute to the assets of the charity in the event of its insolvency. The Insolvency and Dissolution Regulations apply section 214 of the Insolvency Act to charity trustees. Section 214 of the Insolvency Act provides that when a company is insolvent, either on a cash flow basis or a balance sheet basis, the directors' duties must shift towards the interests of the creditors, and indeed the creditors' interests as a whole, and not the interests of a particular creditor or class of creditors, then become paramount. So a school's insolvent if it's unable to pay its debts as they fall due, which is known as the cash flow test, or the value of the school's assets is less than the amount of its liabilities, and that's taken into account its contingent and prospective liabilities, which is known as the balance sheet test. So effectively, insolvency is judged on either or both of those strands. It doesn't, of course, mean that if you're cash flow insolvent at any one point in time, you may not recover that position at a later point in time. So it's always important to look at things over a period, and I'll talk about that shortly. So when the duty of the creditors, duty to the creditors is triggered, the trustees must take every step to avoid incurring additional liabilities. And if the school ends up in insolvent liquidation or administration, the liquidator or administrator will look at the conduct of the trustees to see if they acted appropriately. If it can be shown there was a point in time when there was no reasonable prospect of avoiding insolvency, and at that time the trustees knew or ought to have known that the school was insolvent or likely to become insolvent, then the liquidator may seek compensatory relief against the trustees personally. But that is unless they can demonstrate that they took every step, notwithstanding, to remedy the situation and minimise those losses. Such steps that they may take to avoid the subsequent winding up or administration of the company might be an early voluntary liquidation or administration. But it's important to make sure that you get professional advice from an insolvency lawyer or licensed insolvency practitioner to assist with making that judgment call sooner rather than later if you've got concerns. A charity trustee might also be relieved of if decisions taken transpire to be wrong ultimately, but they were taken in good faith, honestly and reasonably believing them to be in the best interest of the school. So on the 28th of March this year, the UK Business Secretary announced urgent changes to insolvency legislation, which did include the temporary relaxation of the rules around wrongful trading for the 3-month period commencing 1st of March. And this was stated that it was to give the company directors greater confidence to use their best endeavours to trade during this emergency and without the threat of personal liability should the company ultimately fall into insolvency. It seems quite likely that if the economy isn't back on its feet at the end of that 3-month period, that period could be extended. There's nothing to say that it couldn't, but the detail around this hasn't really been announced. And it's not evident really how this is going to work in practice because no formal guidance has been published. The advice that I would give to governors and trustees at this point would be that if the school's in financial difficulty prior to COVID-19, then you can't assume that the relaxation of the rules around wrongful trading is going to be a carte blanche for indifference or inaction for a further 3 months. And in reality, advice needs to be sought as soon as possible. So the practical implications of everything I've said above is that obviously this all requires quite a high degree of awareness and foresight on the part of the charity trustees. Charity trustees aren't always professionals and they quite often come from different backgrounds and experiences. They obviously have the assistance of the bursar, who's often a qualified accountant, who will prepare the accounts and maintains cash flow forecasts, hopefully in real time, and should be making recommendations to the charity trustees on steps that they should take. But the charity trustees need to be aware that whilst they should be seeking guidance from the bursar, they shouldn't put their faith in him or her blindly and must use their own common sense and independent judgment to ensure that they're exercising all of the duties that we've set out. It's worth noting that any cash flow projections prepared prior to COVID-19 will likely need significant remodelling to recognise the challenges, those challenges including uncertainty of pupil numbers and therefore revenue, any tuition fee discounts and potential bad debts arising as a result of parents refusing to pay, and of course extraordinary expenditure which is going to be incurred over this period of time, which wouldn't have been modelled into existing cash flows. The government guidance on school funding for exceptional costs associated with the coronavirus between March and July 2020 talks about grants to cover extraordinary expenditure, but it seems to leave out independent schools as being a party that can apply for those grants. So what are some of the current cash flow uncertainties on a going concern basis that need to be considered? Well, given the current difficulties balancing cash income and outgoings, many schools may become cash flow insolvent, at least in the short term. You need to have a cash flow forecast for a minimum of around 13 weeks, but possibly longer, to understand how cash flow issues will go on and also where any cash is going to come from to plug the gap. You need to be thinking about when the schools will reopen. Education Minister Gavin Williamson said on the 29th of April that there was no fixed plan for opening schools and that it would be on a phased basis. It's not clear what this means in practice, although the government appears to be looking to other countries where the schools are beginning to be reopened. You need to be looking at how the reopening impacts on resourcing, both in terms of teaching staff and administrative facilities. Are there staff who are vulnerable and can't safely return to teaching in the classroom? In terms of exceptional costs of reopening to more pupils with social distancing measures in place, what about the cost of acquiring PPE? Have you factored that in? What about the ongoing testing in schools and any problems or costs that presents? Will there be a need to run 2 learning platforms simultaneously for pupils in school and then those pupils that don't return, perhaps because they live with a vulnerable person or parents who won't allow them to return? Can staff and pupils get to school safely? The school's got a duty to protect the well-being of its staff and pupils, and will there be any costs involved with the school ensuring that staff and pupils can attend school safely? Russell's already mentioned the furlough or the coronavirus job retention scheme, which is obviously a scheme that's on until the 30th of June. And as Russell's reported, the government have announced that they're going to be starting to wean UK businesses off that over July and months thereafter. What will fee income look like going forward? Is it possible that it is possible, obviously, that forecasting can remain robust, but there needs to have been some kind of proactive engagement with parents and stakeholders now to get that robust and visibility on what things will look like going forward. There's obviously uncertainty of the current economic climate, and it makes this a very tricky task to forecast things like pupil numbers going into the next school year. So finally, practical steps to consider as the situation evolves. From the point of view of the trustees, you need to hold regular meetings of the Board of Governors or Trustees, or if a working party of them, if the school's constitution allows that, to make sure that everything is being considered. You need to thoroughly document all those decisions that are being made, including reasons for the decisions taken. Keep all key stakeholders appraised and therefore engaged. It's going to be harder for a creditor that's kept in the loop at this point to later argue that the trustees did not take every reasonable step to avoid insolvency. Consider objectively any cost-cutting measures that might be implemented, and consider any mitigation, including things that Russell's mentioned, including payment holidays on loans, but also rent repayment holidays on premises. Consider any loan or grant funding that might be available, as Russell's discussed. Ensure your cash flow forecasting is updated regularly, daily where possible, if the school's finances are in a difficult position, to give full visibility of the school's financial performance, and be realistic. Don't underestimate or overestimate. Be realistic on what you're forecasting. Be aware of when or if or when the school will run out of money based on the cash flow that you've developed, and then work on a plan to demonstrate that every step is being taken to avoid reaching that point. Also, very important to have in mind that the day-to-day trading costs of the school in the cash flow forecasts are only part of the picture. What if the school was forced to stop trading immediately? So, for example, if the bank ceased funding, or maybe an ongoing sale or merger falls through, does the school still have sufficient assets to remain solvent? Don't overlook the costs of closure of the school, so redundancy costs, including holiday pay and pay in lieu of notice, increased creditor claims, including for school fees paid in advance, banking facility default fees, cost of disposal on assets, including properties, and that one of the main things that schools overlook when considering a closure cash flow is obviously the professional fees and costs of solicitors, accountants and insolvency practitioners that necessarily have to be factored in. Often a forced closure balance sheet looks very different to a going concern one. And then finally, if any of that's unclear, then I think the key is seek professional advice from lawyers or insolvency practitioners to ensure that you don't fall foul. And on that, I'll hand back over to Richard. I think we've got a polling question after this.
Paul, thank you very much indeed. I think, you know, as you were going through the very significant responsibilities and possible consequences of not doing your responsibilities properly as a trustee, I was thinking, oh my word, if I were a new trustee, what would I be thinking? And I might come back to you with a question on that. But I think towards the end, you gave us a lot of very practical pointers, which are really helpful to go forward. And you know, we certainly want to capture those. We have got, before we come to questions for Paul, and then we throw it open for the last few minutes for questions for anybody really. Can we just have our final poll question up, which follows on rather neatly from Paul's presentation. So if we could put the the last poll question up on the screen and ask people to have a look at that. So have a think about your school. Do you think it has now or may experience cash flow insolvency, i.e. unable to pay debts as they fall due at some point during the current crisis? Actually, we seem to have a live percentage coming in, which is exciting. It's like election night. And at the moment, the blue team is winning, but they're all blue. So wait until we've got a few more. But clearly, no is the answer for 60%, which is, of course, that's a relief. That's a good thing. On the other hand, if you combine the not sure and the yes, that's talking about 40% or thereabouts, 39% of the schools on the call. Obviously, it's a sample of about 50 or so in the webinar. So it's not representative of the sector as a whole, but I think, you know, what we're all trying to work out is what the sector is going to look like afterwards. And if this is representative, then whilst the majority are answering no, there is a significant minority who are either not sure or yes. And that, of course, has to be a concern for everybody, sector-wide and also schools-wide specifically. So that's a really interesting piece of information. Thank you. Thank you so much for that. Oh, here we got the red and the blue. So the red team has won this time. But those are the percentages, 64% for no. I think what I've just said, though, still holds true about the overall proportions. So thank you so much for that. Okay. Thank you for that. Let's go back then. And I don't know whether we've got any questions on the Q&A from people for Paul, but I've got a couple of thoughts myself. One thing that you were talking about there, Paul, is considerations about return to school. And I think, if I may, I'm going to slightly park a discussion around that at the moment. I think there is a note from HCR going out today on this, and there's also something that's come from ISBA very recently, and AGBIS is going to be sending something out in the form of sort of questions that governors and trustees should start asking. This will be next Friday, by which time we may have had an update from the government about possible timings or phasings. But there's so much uncertainty around it at the moment, as you said, that I think to try to get into the detail of how that's going to work is not fruitful yet, but it will become so. So please watch out for the updates from all concerned, HCR, ISBA and ourselves, because what governors and trustees will need to be doing is starting to, with their senior managers, create a risk assessment, a risk register and a risk assessment, and then mitigating factors for all the various risks associated with going back in the different shapes and forms in which we might be asked to go back. So that's a sort of general holding position on that, but more information will be coming. Kate, are you happy with that, what we said on that at the moment?
Yes, no, absolutely, Richard, thank you. No, that's correct. Richard, do you mind if I just jump in very quickly before you move on to any other questions? I just wanted to comment on the poll, the really interesting poll that you just did in relation to whether schools are concerned about their cash flow at the moment. And for me, what was really interesting, and I think you touched on this, was the 24% clicked unsure. And what I would say about that is, what I would really stress, and what Paul has brilliantly just sort of covered, is what is really important for you as trustees is that unsure becomes a yes or no. And so what you need to be doing is looking at the budget you produced for this year and redoing it based, and I know it's really difficult because at this point it's very hard to know what your fee income is going to be for this term, and I'm guessing that could be why a lot of people clicked unsure. I mean, all you can do is try and make a projection and almost look at a worst case scenario, is probably what I'd suggest, unless Paul disagrees, and redo that budget to make sure that your cash flow is going to be sufficient for the school.
Thank you ever so much, Kate. Absolutely, I was going to say the same thing, and with great thanks to Paul for those practical things he was saying in the sort of last third of his presentation there, and pointing out the importance of foresight and awareness, which are two words you used, I think, Paul, for governing bodies and trustees. Not putting blind faith in the bursar, but actually working with the bursar in the appropriate way to make sure that those cash flow forecasts are regularly updated. And not just the bursar, the head, by the way. The head can't just step back from any financial responsibilities. They are in charge of the whole operation, and they need to be involved in that and know enough about it. And finally, in terms of cash flow forecasts, of course, remembering the obvious thing that our cash flow in schools has significant peaks and troughs. And there will be months when the cash flow test is absolutely critical. And that's really where you need to be looking at where the rubber hits the road, if you see what I mean. Those times when you still have to pay the staff, frankly, but you haven't got your fees in, and you don't even know what your fees are going to coming in are going to be, really. So can you just say something about that in terms of timing and the balance between executive and governance in all that respect?
Sorry, so just in terms of, yeah, I mean, it's recognised that obviously schools have those peaks and troughs, and that's well known. So I think if you were if your conduct was being examined at a later point in time in relation to whether or not you've fulfilled your duties, I think it would be reasonable to assume that it would be considered in light of those peaks and troughs that are an industry norm. Does that help to answer the question, or sorry, could you rephrase it? If
no, it does help to answer it. I suppose I was also asking about practical things that governors and trustees need to remember when working with their bursar to get the balance right between supporting the team and not interfering too much. It's their responsibility, but they can't do all the work on it.
Richard, I'll pick that up. Yes, I think what you're saying, it's this eyes on, hands off, isn't it? I think what you're saying is, as a trustee, at the moment, it is your responsibility to have oversight of, for example, the cash flow statement, and in fact to ensure that a cash flow statement has been produced, it's been amended as things progress and change, which of course is happening every day at the moment. But it's the bursar who will be actually producing that cash flow statement alongside or the finance director and presenting it to you as trustees. Does that?
Yeah. Yeah, so we've got to be sufficiently across the detail, but obviously supporting them. Paul, I think that was the sort of way I was going.
Yeah, no, I agree with Kate. I mean, I think that's right. With any business, you obviously employ professionals and you rely on their advice to an extent. But it's vitally important, especially at the moment, you don't abrogate your responsibilities to consider things and work with those professionals, so the bursar and the head, to make sure that there's a holistic view and everybody is on the same page.
Yeah, and I would add, by the way, and there is another question that's come in, I'll put to you maybe as our last question before we go to a final general one. I just would add on that if, like me, you're not a financial specialist, you've got other expertise, you're not on the board primarily for your accountancy or financial or legal background even, again, you can't abrogate your responsibilities. We are all equally responsible for these things, and most particularly when schools are looking as if they might be getting into difficulties. But we won't be expected to have the same level of expertise as the accountants and the lawyers and so on, but we still have to take our responsibility and actually asking what I called earlier the daft laddie question, or the daft lassie question, the innocent question. I may not be an expert in this, but please can you explain why, is sometimes the most powerful thing, because it'll provoke a discussion that perhaps the technical expertise won't provoke. Do you see what I mean? So please, yeah, if you're on the call and you're not a financial expert, don't be fazed by all this. You've got a powerful role to play, and a very equally important role to play as everybody else, I think. So I think just with that in mind, I just want to draw Paul's attention to the other question that's come in. Can you see that on the Q&A, Paul, from John Murray?
I've got from John. Is this the notwithstanding other liabilities? Is there a benchmark ratio of borrowing to net asset value, which is generally considered safe?
Yeah.
Is there a benchmark? I wouldn't say there is a specific figure that I could, or a benchmark that I could put on that. in terms of, I mean, ultimately, as said, if you're looking at the balance sheet test, then the test is, do your liabilities exceed your assets, or vice versa, and that is the test of balance sheet insolvency. So there isn't really a, if that answers the question. Otherwise, I'm not sure if it might be in relation to banking.
I think it does answer it, although there are benchmarks, which I'm sure a lot of people on the call are familiar with, benchmarking surveys in the sector as a whole. Obviously, they haven't been done during the COVID crisis, so they may or may not apply in the same way. But there are sector benchmarking things done by various firms of accountants and consultants on aspect. I can't immediately pick out whether there's one on the borrowing to net asset value. We can follow that up afterwards and point you in the right direction, John and others, when we do the posting on the website of the recording afterwards. I think it's certainly worth using the benchmarking that is available in the sector as reference point, even though these are not normal times for benchmarking. We've got to bear that in mind, as it were, as well. Don't know if anybody else wants to come in on that. Russell?
No, I don't think it's in terms of the way that banks looks at things. I don't think it's a big thing for them. It's much more around you know, the service, your ability to service your loan, and it's much more around you know, the individual robust nature or otherwise of the institution that's being looked at. So no, I don't think benchmarking plays a big part in banks' approaches to things.
Yeah. Okay. That's very helpful indeed. And as I say, if we find other pointers for you on that one, John, or others on the benchmarking, we will post them with the recording afterwards. That, I think, probably comes to the end of the questions that are outstanding on the Q&A, except for the ones which we said we'll come back to later, like the one about the Scottish Charities regime and so forth. But are there any other comments or questions that anybody on the panel would like to add in summary before we finish? We've probably got a couple of minutes before we have to finish the webinar. Kate, Russell, or Paul, anything else you'd like to add or comment on what's been discussed, or any of the polling?
The only other thing that I would say, Richard, and you've already touched on this, as has a lot of other people, the other panelists, but for me, what I would say is, as you've sort of said, please, everyone that's listening to this, please don't go away thinking, oh my goodness, I hope we haven't ruined your day. I think the message here is, as a trustee, a director of a company, you need to be able to show that you have considered these things, and you need to be able to, that you've considered them and that you've acted upon them when, if necessary. And if required, you have sought advice on them. And if you can do that and you have a record of that, then you are fulfilling your duties as a trustee, and you are acting in the best interests of the school.
Thank you so much. And I would just add, and by way of sort of coming towards a summary, but if any of our other panelists have a burning thing, please raise your hand and I'll bring you in before I finish. But I would pick out what's come up a couple of times, which is there are situations where trustees and governors have a duty, and it is actually a legal duty, to take appropriate advice. And I can't think of many situations that would be more likely to qualify than the sort of situations we're in at the moment. I'm not just saying that to try to push you all in the direction of HCR, although they're a wonderful firm, but there are lots of others out there. And advice can be paid for professional advice, or it can be guidance from AGBIS, and our support services go on throughout this crisis. But I do think we need to remember that we're not in it alone. There's an awful lot of information. Many of you will want to listen to this webinar again on the recording, I suspect, because a lot of detail to take in there. And you know, you may need to just pick up one or two things again. And please come back to us afterwards if you have any follow-up questions. So take advice, be aware of the responsibilities and the consequences if things go wrong, but don't be fearful about that. Just be advised and go forward together with the guidance you get from others in the sector as we all tackle what is a completely unknown and unexpected landscape that none of us have ever had to navigate before. So all of us are there to help, and please don't hesitate. On that note, I would say, just draw your attention to the fact that there are a whole series more of these free webinars from AGBIS. I hope you've all got the program. It's on our website, and we will be continuing these on through this term. I think there are about 16 or 17 of them in total, something like that. We will be doing more webinars next term. Those, I'm afraid, won't be free, but these ones certainly are during this extraordinary time. And I'm just going to have one more check on the questions. No, just get one or two thank yous coming in, which is wonderful. Thank you so much for attending. Really appreciate it. And there's a lot of stuff to take away and food for thought, as it were. So with my warmest thanks to Kate and to Russell and to Paul and to the technical team behind the scenes, and with a final reminder to all clerks and bursars on the call that you'll get an update from AGBIS every Friday with our latest news. Please watch out for that and pass it on to governors. Can I thank you all for attending and wish you all a very good day. Best wishes with all the challenges that we've all got to face. Thank you to our team, and bye-bye.